You knew, or you should have known, that this was an inherently dangerous act. You don't fire shotguns inside buildings with or without blanks. Past Commodore Joe Tringali, coming to you from the Academy of Yachting. When we began this series a number of weeks ago, I told you that the Academy of Yachting was created originally for the benefit of yacht clubs and yacht club members. We were meant to be a resource for club members. We were to answer questions about protocol, law, everything. As time went on, it became apparent that we had the answers to questions that were far more all-encompassing than yacht clubs. And that question is going to be answered today. And the question is liability for officers and directors. Can you be held personally liable for negligence that happens at the club, even though you do not participate in the negligent act? I'll tell you right now, the answer is yes. And I'm going to cite my own book, You, Your Club, and the Law. This is not a commercial, but I highly recommend this book because it explains everything you need to know about your relationship with your club and the legal system. Okay, we're talking about negligence. And the classic case comes out of Florida, actually. It's called Guyton versus Howard. It was decided in 1998 by the First District Court of Appeal. The fact that it's a Florida case is really not relevant to this discussion because it is an extremely well-researched opinion that cites case law treatises from all over the country. And it lays out in detail what happened and what you need to know. Okay, James Guyton, I'm going to read you just the first line. James Guyton sued the ancient Egyptian Arabic order of nobles, mystic shrine of North and South America, and the local shrine group. Here's what happened. This group had a skit that they performed as part of an initiation ceremony. And the skit was this. It was called The Return of the Drunk. What happened was, during the course of the meeting, one member pretended to get drunk, spilled a lot of liquor all over the place, and was basically thrown out of the meeting after a lot of pushing and shoving and voices being raised. He was ejected from the meeting. Sometime later, the drunk returned with a shotgun, loaded with blanks, of course. And he forced his way into the meeting. Again, there was pushing and shoving and voices raised, and he pulled the trigger and fired the gun. Now, this was supposed to be, of course, a test of strength, a test of courage. You know, after it's over, after all, men will be boys. There's going to be a lot of, ha, 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 boy, we scared the crap out of you, didn't we? Ha, 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 ha. You know, a lot of good-natured fun, let's all have a drink. Except for this. Mr. Guyton was blinded in one eye by that shotgun blast. And when that happened, all thoughts of conviviality and congeniality and good times, they went out the window. And Mr. Guyton went to see a lawyer. And the lawyer sued. And he sued the local group and each officer and director individually. Now, the local group said, hey, you can't sue us. We're not incorporated. You know, we're just a group of guys over here. We don't have any legal status. That's okay, because we will take our judgment against each and every officer and director. Now, two of those directors said, when they got into court, their defense was, wait, I didn't participate in this stupidity. I was in the audience. I was watching this. And the court said, too bad, because here's the rule. You knew, or you should have known, that this was an inherently dangerous act. You don't fire shotguns inside buildings with or without blanks. That's a dangerous thing to do. Anybody would know that. You should have known that. And you set the wheels in motion by your vote. You voted to have this happen, and it happened, and you are responsible. It doesn't matter if you were the guy with the gun, or you were the guy doing the pushing and shoving, or you were in the audience, or you were visiting your mother-in-law in Kansas City. Too bad. You put the wheels in motion, so you, Mr. Director, Mr. Officer, are liable for Guyton's injuries. Now, is that a harsh rule? Well, I don't think so, but, you know, a lot of this negligence stuff is determined by juries. And now let me tell you one other case that has some very, very interesting language about that very subject. Who makes those decisions? This case is called the Rocky Bayou Country Club. It originated in Niceville, Florida, which is up in the Florida Panhandle. The case is Furch versus Rocky Bayou Country Club. And what happened there is this. A member of this country club was at the bar, was known to have a drinking problem. And he got drunk. And frankly, the country club did the right thing. The bartender shut him off and would not allow him to drive home. Well, Mr. Furch was a good Samaritan, member of the club. And he said, I'll drive him home. You know, hey, come on. While the drinking was going on, while this was all taking place, the gentleman who was inebriated was showing off his newest toy. His gun. Loaded gun. Hey guys, isn't that great? Look at it. This is my gun. Loaded. How about that? Well, on the way home, that gun was fired, and Mr. Furch, the Good Samaritan, suffered a bullet through his heart, and of course he was dead. And his estate sued the Rocky Bayou Country Club. Okay. Now, we're not going to discuss something called the Dram Shop Act. So for all you lawyers out there, we'll get into Dram Shop a couple weeks down the road when we talk about liquor licenses. We're just discussing negligence. But here's what you have to know. First of all, well, let me give you the background here just a little bit. The trial court threw this case out and said, look, there's no foreseeability here. You know, there's no way the country club could have foreseen the Good Samaritan being shot. It's not like he was run over. It was, you know, I mean, he was shot. That's just not foreseeable. The appellate court reinstated the case and said, no, that's for the jury to decide. And here's what I want you to hear, okay? The court said, a person who sells or furnishes alcoholic beverages to a person of lawful drinking age and who knowingly serves a person habitually addicted to the use of any or all alcoholic beverages may become liable for resulting injury or damage. The evidence is for the jury to determine. Same thing about foreseeability. They said it's not a legal issue. That's for the jury to determine. Here's the thing. When a jury makes a determination, it is a determination of fact, and it's not appealable. I spent 24 years representing the state of Florida in appellate courts. When you appeal a case, it's not a do-over. You come to us with a presumption of correctness. We presume that the trial court is correct. Once the jury makes a determination of fact, there's no super jury. That's it. That's settled. The thing that we discuss at the appellate court are questions of law, just like the question of law that was decided in the Rocky Bayou Country Club case. The court again said those questions are questions of fact for the jury. Okay, I think I just ran over about 1 or 2 minutes of time here, so I'm going to leave you with that, and we are going to come back next time to talk about gross negligence and how that can really affect your club. So until then, it's past Commodore Joe Tringali from the Academy of Yachting signing off.